Hello, my name is Jonathan Williams, and I'm an attorney with Clarity Legal Group. We are a triangle law firm who works in the area of estate planning and elder law and estate and trust administration, which means we help clients and their families deal with wills and trusts, incapacity, health directives, powers of attorney, guardianship matters when necessary, Medicaid eligibility and things like that, and also helping families deal with their loved ones' affairs after death through trust administration or estate administration with the probate court. We are very honored and privileged to be here for the Caregivers event. We admire caregivers very much. It's such a labor of love, and we're so happy to provide this support for you. We hope this information will be good for you. We're going to talk today about legal documents for the caregiver. That just means legal tools that are available to make a caregiver's life easier. You know, a big part of a caregiver's role is to make sure that their loved ones' financial and legal affairs are well managed and taken care of. Also, that healthcare decision-making is taken care of and made as easy as possible. And so we're going to talk about the tools that are available to help that go better and easier. And this may serve for some of you as a way to understand a little bit about the plan that may already be in place for your loved one. Your loved one may have already made a power of attorney or healthcare directives that involve you as their agent or healthcare agent. But for others of you, this may serve as a roadmap or a checklist of things that you may want to make sure that your loved one has the opportunity to consider and perhaps put in place if that is needed and if your loved one has the legal capacity to act to sign these legal documents. We want to jump right into it since we're limited in time. We're going to talk about two main domains, that is healthcare decision-making as well as legal and financial decision-making and management. Starting with healthcare, we're going to talk mostly about the healthcare power of attorney. The healthcare power of attorney is a legal document that allows your loved one, who I'm going to probably call the principal at times during this presentation, to name a healthcare agent whom they trust to make medical decisions on their behalf if there ever comes a time when they're not able to do that for themselves. So the principal will name a healthcare agent. The healthcare agent will be able to make medical decisions at the appropriate time. So how does all this work? Well, of course, the most important decision is who should be the healthcare agent. And so we would want, if we're helping a principal do a healthcare power of attorney, we would want to make sure we knew whom they trusted to make these decisions, whom they felt had the best knowledge of their health situation, their values and goals and priorities, so that they would have the best chance to get the healthcare outcomes that they would want. But just as important as it is to put people you trust on the healthcare power of attorney, you also want to be thinking about who should not be on the healthcare power of attorney. For example, if we have a principal who is married, maybe their spouse is not the right choice because their spouse is incapacitated themselves, or there may be some strain in that relationship. It would be important to name someone else as healthcare agent and put backups in place so that that person who is maybe not the right choice, maybe there's an adult child who is not in the best relationship with mom or dad, and we don't want that person to have the ability to step up and say, hey, I'd like to make medical decisions here. So having a healthcare power of attorney can be as much about making sure the wrong person isn't involved in healthcare decision-making as it is in making sure that the right people are. So oftentimes we're not only naming a healthcare agent, we're naming a backup healthcare agent and sometimes a second or third backup, so that we know we have some contingency plans in place if the person that is selected is not available for some reason. Another question about the choice of healthcare agent is whether or not it makes sense to name co-agents. That certainly is allowed under North Carolina law, and we do from time to time help our clients name co-agents so that the agents would have essentially equal power to manage healthcare decision-making. In the abstract, we generally don't recommend this because One of the primary goals of doing a healthcare power of attorney is to make sure that if there is disagreement among the friends and family and loved ones about what course of treatment should be taken, that we have a document in place that can identify a final decision maker if a disagreement needs to be resolved. And so in the abstract, I don't tend to recommend co-healthcare agents, although certainly every family and situation is a little bit different, and sometimes it makes a lot of sense to name co-agents. So we take that on a case-by-case basis. Now, the healthcare agent, once the document is signed, does not necessarily immediately have the power to get involved and start making healthcare decisions on behalf of their principal. In fact, the document is going to say very clearly that the healthcare agent has no power to act unless or until the principal's doctor confirms that the principal is unable to make their own healthcare decisions and communicate those decisions effectively. Until that happens, until the doctor confirms incapacity, the healthcare agent is really on standby. They don't have immediate power to act. But if there comes a time, and it might be temporary or it might be less than temporary, where the principal is no longer able to make their own decisions and communicate those decisions effectively, then the attending physician can step in and say, this person is incapacitated. We're now going to be looking to the healthcare agent to provide decisions and informed consent as needed. Now, the powers that the healthcare agent will have to act are going to be very comprehensive. The document is going to list all sorts of things that the healthcare agent will be able to do, and it's meant to be an everything in the kitchen sink type of approach, so that the healthcare agent will be able to carry out whatever their principal's wishes might be and act in coordination with the medical providers to follow doctors' recommendations as needed. And so the powers are meant to be very comprehensive. But there is the opportunity in the document to limit the healthcare agent's powers if that is necessary. So, for example, if the principal has particular kinds of treatment or categories of treatment or medication or procedures or things like that, that they do not want their healthcare agent to have the power to consent to, then those limits can be placed in the document. For example, if there are religious or moral beliefs about a particular kind of treatment that we don't want to undergo for those reasons, or it might be practical considerations that you simply don't prefer this kind of treatment, or you don't think that the benefits are going to outweigh the cost of that particular kind of treatment, you can make a limit and say, my healthcare agent cannot consent to this type of treatment. We urge folks to be really judicious about that. We, in the abstract, want the healthcare agent to have as much power as possible to follow what a doctor's recommendation might be. But in the right circumstance, if there's a concrete and strong and clear wish to make a limit on the healthcare agent's powers, that can be put into the document as needed. Now, the other set of powers that a healthcare agent can have are the powers to dispose of remains after death. Now, these powers do not apply automatically. The healthcare agent only has these powers if the principal says so in their document. But the principal can give the healthcare agent, for example, the power to initiate organ donation if the principal would like to be an organ donor. They can also authorize the healthcare agent to initiate an anatomical gift or anatomical donation if they would like to do that. The principal can also put binding legal instructions in place regarding the disposition of remains after death. So, for example, the decision about cremation versus burial and where the remains should be buried or interred as appropriate or scattered in the case of cremation. Those are powers that can be given to the healthcare agent. They're not there automatically, but the principal can opt in for those. One more thought about the healthcare power of attorney before we move on to these other documents, and that is, since our audience here are caregivers, how should the caregiver, if they are named as healthcare agent, how should they think about their role as healthcare agent? How should they approach the job, so to speak? And the law is not particularly clear about this. In fact, the law essentially says if you're the healthcare agent, you have the power to act. and there's no real guidance in the law about how you might approach your power to act. But we recommend to our clients, and we might urge you as well, to think in terms of making sure that your loved one, your principal, has the best opportunity to get the outcomes that they would want. And to be a little bit more concrete about that, we would urge healthcare agents not necessarily to act with their own judgment based on what they might think is right and what they might do, but rather what they believe their principal or their loved one would want if they had the ability to speak for themselves. Because ideally, we want our loved ones, our principals, to get the outcomes that they would choose for themselves and that they want. And so we would urge that you think about your role as healthcare agent in those terms as well. And you don't necessarily know in all cases what your principal would want, but taking the opportunity to have that conversation with your loved one so that you can learn a little bit more about their goals and their values and their priorities can not only make sure that your principal is going to have better health outcomes that are more consistent with their values and priorities, but can also be a way for loved ones to really have a meaningful conversation and draw you closer together. So that can be a side benefit of going through this process. Now, let me move on to the other health directive that I want to talk about. That's colloquially called the living will. The formal name in North Carolina is the Advanced Directive for Natural Death. But we still very broadly call it the living will in North Carolina, and that's a document where a principal can make instructions to their doctors about end-of-life care. Namely, do they want to decline life-prolonging measures at the end of their life, or would they want those measures to be applied? Now, you might ask yourself, what is a life-prolonging measure? Can you give me a list of particular treatments that are or are not life-prolonging measures? And the answer is no. In fact, whether something is life-prolonging measures or not really depends on the goals and the expectations of treatment. For example, if I have some sort of stomach issue and I'm going to require surgery in my gastrointestinal tract, maybe my doctors would put me on a feeding tube for a few days while my system has a chance to heal and get back its function. That's not life support. That's just giving me the treatment I need to get better and get back on my feet. On the other hand, if I'm in an auto accident and I've lost consciousness and my doctors have determined that I'm never going to regain consciousness, well, if they're putting me on a feeding tube, that's not because I'm going to get better. That's just to prolong my life artificially, and that would be considered life-prolonging measures. Now, the statute in North Carolina invites a principal to decline life support if they want to in up to 3 situations. And those, I'll sort of summarize them for you, are imminent death due to illness or injury, meaning due to some incurable injury or illness, you're at the end of your life in terms of minutes or hours, perhaps. The second situation is permanent loss of consciousness. So, like I mentioned earlier, with the possible auto accident where your doctors determine you're never going to regain consciousness and you have a high degree of certainty that that's the outcome, then that can be another opportunity to say, I don't want life support. And the third one is permanent loss of cognitive function. So if there's a traumatic brain injury or a very advanced dementia illness, so that the principal or the patient really isn't really here anymore, they're not really interacting with the world anymore due to the loss of cognitive function, you can decline life support in those situations as well. So a principal who's making this document can decline life-prolonging measures in all of those situations, or just 2 of them, or just 1 of them. And of course, if they don't want to decline it in any of those situations, then they don't have to do a living will, and that's perfectly fine as well. The other main decision point in a living will is, how does this interact with the healthcare agent? To illustrate that, I want you to imagine a scenario where your loved one is in one of these terrible situations, they're at the end of their life, and they've said, I don't want to receive life-prolonging measures in this case, but the healthcare agent is present, and the healthcare agent instructs that life support be administered. How should the doctors respond to that apparent conflict? Should they go with what's in the document, what the principal has said ahead of time, or should they go with what the healthcare agent is saying now? And the document, the living will document in North Carolina, invites the principal to resolve that conflict ahead of time, to say, hey, if there's a difference between what I've said here and what my healthcare agent may instruct you in the future, I want you to go with, on the one hand, maybe what's in the document, or on the other hand, go with what the healthcare agent is going to say. And each person can decide for themselves whether they want their living will to be the final word on this, or whether they want their healthcare agent to have the final word on this. There's no right or wrong answer to that question, but a principal can make that decision for themselves. Now, having spoken a lot about healthcare planning, those are all very important tools and issues. I do also want to speak briefly about legal and financial planning. If you're a caregiver and you want to make sure that your loved one's bills are continuing to be paid, that their finances are being managed well, that their real estate is being properly taken care of, what tools are available for that? Well, the main tool for that is called the General Durable Financial Power of Attorney, and that's an all-purpose document that names a person called an agent, and the agent will have the authority that's given them in the document to manage the principal's legal affairs, financial affairs, property matters, and things like that. It's hard to overstate how important this document is. It's a very important tool. If there is no power of attorney in place and your loved one becomes incapacitated and their legal or financial matters need to be managed, if they've not made a power of attorney, then they've given no one the authority to act for them. And therefore, the only way that those assets can be managed would be through a court-supervised guardianship. And that's, in most cases, a more cumbersome, a more expensive and time-consuming situation than is really warranted for a lot of families. There are times when guardianship is appropriate, but for many people, doing a power of attorney instead will be a much less intrusive and more flexible and easier to manage situation than going through the court and getting guardianship. All the same factors apply for the power of attorney and naming an agent that applied when we talked about naming a healthcare agent. Here we want to make sure that we're naming someone that the principal trusts, someone who has the integrity to act in the best interest of the principal and not take advantage of the situation for themselves. We also want to name someone who is reliable, meaning that they're going to be able to manage things appropriately and not let things slide, but be on top of things. And we also want to think a little bit about who has room in their life or room in their schedule to be able to take on this responsibility. So that's going to be different for different people, but naming the right agent is, of course, a very critical decision. And you can name co-agents on a power of attorney. That's reasonably common, more common than certainly naming co-healthcare agents. It might make sense to say, well, I'm going to have this child on the document because they're local and they can take care of things around town, but maybe this other child is the one who I trust to make money management decisions, and so maybe it's appropriate to have both children on the document so that they both can act for the principal. But of course, anytime you're naming co-agents, you certainly have the possibility that those agents may have a disagreement about what should be done. They may not communicate effectively, or they may just sort of pull in not quite the same direction. And so you want to think about that when you're thinking about whether we should have co-agents or not. But it is a reasonably common choice and appropriate in a lot of situations. The other big piece that I want to talk about with the power of attorney is when the power of attorney becomes effective. I said previously, talking about the healthcare power of attorney, that it only becomes effective when the doctor says that the principal can't act for themselves. They can't make their own decisions. The financial power of attorney can be set up the same way if the principal wants it that way. You can say that my agent only has the power to act if my doctor determines that I'm unable to manage things for myself. We don't do a lot of powers of attorney that way in our office. I don't recommend it in the abstract. Certainly, it's going to be appropriate in some circumstances, and sometimes folks are really going to want it that way. But the practical outcome of that is that if you're a principal and you become incapacitated, and your agent needs to go, say, to the bank and get their name on the account as POA so they can start taking care of your bills and making sure that your finances are well taken care of, not only do they have to show up at the bank with a copy of the power of attorney, now they also have to provide proof that you are incapacitated before the bank is going to honor that document. And of course, the bank teller you may be working with probably isn't going to be able to approve that on the spot. They're going to want to send that up to their home office and have the legal department look at it. And does the doctor's letter say everything that we want it to say, or are we going to want the doctor to reword certain parts of it so that the legal department is okay with approving this power of attorney arrangement? It's not the end of the world. But it can add an unnecessary impediment or another hoop to jump through for the agent that might make their ability to manage the principal's affairs a little bit more difficult in what might be a relatively urgent situation. So in the abstract, our advice is generally to give the person you trust the power to act so that when they need to act, they don't have to prove that you're incapacitated. They'll be able to make those decisions and manage those things as soon as needed. So again, there's not a lot of more I need to talk about in terms of how the power of attorney works, other than to again emphasize this is a very important document because it allows your loved ones, if you're an older adult who may need help at some point, it allows your loved ones to have the tools that they'll need to manage your legal affairs, to manage your finances and your bill payments in the event that you become incapacitated. So it's a very important document. Now, all of these documents that I've talked about, the healthcare power of attorney, the living will, and the financial power of attorney, there are state-created model forms that are available that without cost. So if you did a web search for North Carolina statutory power of attorney form, you would be able to find that document. Of course, as a practicing attorney, we certainly recommend legal services here to make sure that the documents fit in well with the overall estate plan and the situation that the client may be finding themselves in. But if cost is a factor or access to an attorney is a factor, those forms are available through the state, and I would say they're better than nothing. So we do recommend that you think about these issues carefully, and if these tools can be put in place for you and your loved one, they can be a big help for you. So that's all I have to talk about today. Again, we're so honored to be here with you to provide information for this event. We really admire caregivers and want to support them as much as possible. And we certainly wish you and your loved ones all the best as you go through this journey together. Thank you so much.